They're leading the way. First in the country.
Your Excellency and Mr. Wilson, Sir Anthony, colleagues, ladies and gentlemen, welcome to this wonderful occasion in the Banco Court. We are in a building that did not exist at the time the great man who will be the focus of our attention tonight was appointed to the New South Wales Court of Appeal, or indeed at the time of his subsequent elevation to the High Court of Australia. The court sits on land cared for thousands of years by the Gageler of the Eora Nation, and I'm sure that you will all join with me in paying respects to elders past, present and emerging. I particularly welcome Sir Anthony, many members of his family, and the legions of his friends and admirers. He's still clearly able to pull a crowd. Sir Anthony may also be interested to know that earlier today in this very courtroom, his 1987 judgment in Flaherty and Gageler was being debated by Brett Walker, Noel Hutley and Brendan Lim. It may have been useful if he had arrived here earlier. Sitting with Sir Anthony at the bar table are his two sons, Michael and David, some of his former associates who have travelled from interstate to be with us today, Justices Stephen McLeish and Chris Walker of the Victorian Court of Appeal, both also former Solicitors General of Victoria, and Miss Michelle Healy, who was Sir Anthony's associate with me in 1991. And Justice Leeming is hovering somewhere in the crowd, much like a floating charge about to crystallise. I also had the privilege of being Sir Anthony's associate more than 30 years ago, and we have maintained a terrific friendship ever since, as have all of his former associates. Our main speaker tonight is another one of those associates who has done quite well himself, the Honourable Stephen Gageler, AC. His Honour will speak after Justice Jeff Lindsay, who is wearing his Forbes Society hat. The Forbes Society has supported the publication of this book, and we should all be grateful for the work of the Forbes Society in fostering our appreciation of the legal history of this state, this court, and indeed the legal history of the nation. Justice Gageler will in turn be followed by Professor Barbara McDonald, one of our leading academics, a stalwart of the Sydney Law School, and an editor, together with Ben Chen and Geoffrey Gordon, of the wonderful collection of essays that comprises Dynamic and Principled. A vote of thanks will then be given by Professor Simon Bronnett, Dean of the University of Sydney Law School, which is Sir Anthony's alma mater. There is a famous story, perhaps apocryphal, but never denied by Sir Anthony, that Michael McHugh, on his return from sitting on the Hong Kong Court of Final Appeal, said to Sir Anthony, and I quote, "They regard you as a demigod up there." To which Sir Anthony responded tersely, "Who used the word demi?" Sir Anthony, the book to be launched by Justice Gageler may well become Exhibit A in your deification. I sincerely hope that you and your family enjoy this occasion. We're all here because we respect and admire you so deeply, and we pay tribute not only to your public achievements, which are vast, but also for many of us here tonight, we thank you for your friendship, wisdom and inspiration over the years. Justice Lindsay.
Your Excellency, Chief Justice, Sir Anthony, members of the Mason family, friends one and all. On behalf of the Forbes Society for Australian Legal History, I congratulate the editors, authors and publishers of the book to be launched tonight, Dynamic and Principled. The Society is honoured to have had an opportunity to support the publication. It is altogether fitting that Justice Gageler launched the book. He is well known to us all as a senior judge of the High Court of Australia, a distinguished former Solicitor General of the Commonwealth, and an honoured member of the New South Wales Bar. This event serves both to launch a book and to celebrate Sir Anthony Mason's life in the law. Justice Gageler is well placed to lead the way on both counts. He has two particular qualifications for the job tonight. First, he is the author of the leading essay in the book, having written chapter 1 on the coming age of Australian law. Secondly, and I think perhaps more importantly, as a former associate to Sir Anthony and as a long-standing member of Sir Anthony's extended legal family, he is well able to express our appreciation of Sir Anthony's contribution to Australian law. Please welcome Justice Gageler as he launches Dynamic and Principled. Justice.
Thank you, Justice Lindsay. The publication and launch of this book in 2022 has been quite deliberately timed to occur in the year that marks the 50th anniversary of the appointment of Sir Anthony Mason as a Justice of the High Court. And I commence by hailing the presence here this evening of Sir Anthony himself. 50 years after his appointment as a Justice of the High Court, 53 years after his appointment as a Judge of the Court of Appeal of the Supreme Court of New South Wales, 58 years after his appointment as Solicitor General of the Commonwealth, and 71 years after his admission to the New South Wales Bar. There are some other milestones in his extraordinary career which I will mention. That will do for a start. This is the only time in our long relationship when I have found myself on the bench and Sir Anthony has been sitting at the bar table. His appearance is made all the more formidable by the impressive array of juniors that he has assembled on either side of him and that he has sprinkled through the audience. With the authority that is temporarily afforded to me by our relative positions, I'm inclined to say, Mr. Mason, do you move? What I will say, unprompted by any motion and presuming to speak on behalf of the many, many admirers who have gathered today physically in the room at this event and who will be joining in virtually to see the video presentation in due course, is Sir Anthony, thank you for honouring us with your presence. Thank you for your service to Australian law, to the Australian legal community, and to Australian legal institutions. Thank you for the contribution through that service to our national development. But for you, the book we have come to launch today would have no hero, and but for you, our national story over the last half century would have had a different plot. Now, there might seem something odd about launching one book by talking about two other books, but that's what I'm going to do. The two other books help to put this book in context, and I am not alone in thinking that. The editors of this book, Barbara MacDonald, Ben Chen, and Geoffrey Gordon, make reference to both of these other books in their engaging introduction. The most recent of the two books, and I brought them both with me, bought three books, the one I'm launching and the other two. The most recent of the two books is this one. It was published by Cambridge University Press just last year. It is a collection of essays entitled Towering Judges, a Comparative Study of Constitutional Judges. The essays in the book examine the work of 19 judges of apex and constitutional courts in 14 jurisdictions, national jurisdictions around the world. The judges who are presented in the book as towering judges are identified on the basis of having stood out from other judges of the courts of which they were members and having had a unique impact on the trajectory of constitutional doctrine within their respective national jurisdictions. Australia's Sir Anthony Mason is amongst them, alongside Israel's Aaron Barak and South Africa's Arthur Chaskalson, to mention just two others. One essay in the collection is by a veteran Harvard law professor, Mark Tashnet. It is a sustained examination of the phenomenon of the towering judge. The essay makes three main points. The first point is that to refer to a towering judge is to refer to the standing of that judge in relation to other judges. Some judges do tower over other judges, and most judges who are seen to tower over other judges do so for the basic and unsurprising reason that they are seen to be much the better lawyers and to have much the better judgment. The second point is that toweringness is historically contingent. The conditions that allow for or support a judge to be recognised as a towering judge vary from time to time. And the third point is that perceptions of toweringness, that's the language he uses, themselves can vary through time. Like wines, the judgments and reputations of some judges age better than the judgments and reputations of other judges. During its 119-year history, the High Court of Australia has had 55 judges. Nearly all have been adequate. Some have been outstanding, including some here tonight. Just two have been generally considered towering. The other was indisputably Sir Owen Dixon, who served on the court as a justice and then as Chief Justice for a total of 35 years, more than half again longer than Sir Anthony's period of service on the court as a Justice and Chief Justice, which spanned a total of 22 years. Unsurprisingly, several of the contributions in the book we've come to launch involve an element, very large element of comparison and contrasting of the judicial contributions and in particular the judicial methods of these two towering figures. The judicial method of Sir Owen Dixon will be forever tied to the label of strict and complete legalism, a label he chose for himself at the time of being sworn in as Chief Justice. The label has come to mean different things to different people and is unfortunately too easily equated with formalism, which it never was. The judicial method of Sir Anthony Mason defies labelling. He has never sought to ascribe one to himself, although at the time of his own swearing in as Chief Justice, he made a point of speaking of courts having an obligation to shape legal principles to the conditions of Australian society. He spoke of the need to ensure that judicial development of Australian law responded dynamically to conditions of Australian society. He spoke of the need to ensure that that judicial development is principled, orderly, and evolutionary in character. Jeff Lindell has observed of Sir Anthony's extrajudicial writings more generally that he seems to have been keen to emphasise the inevitability of change in the development of all major areas of law and to have had as his concern to explore not whether but how the law, and especially judge-made law, should respond to that change. Sean Brennan, whose contribution to the book we have come to launch, Sir Anthony singles out in his foreword, for special mention refers to the Mason judicial method in terms of realism. Tinas Rue and Rosalind Dixon refer to it in terms of functionalism. Mark Leeming describes it as principled development. Stephen McLeish describes it as involving preparedness to accept that the law can change over time, coupled with a keen respect for the role of precedent. Peter Durangelis describes it as involving serious engagement with competing perspectives and a balancing of competing interests. The editors have sought to capture it in the title dynamic and principled, an epithet which Andrew Bell, in his contribution to the book, specifically embraces. Now, what would have happened, I found myself asking myself as I pondered those and similar descriptions of Sir Anthony Mason's judicial method in the book. Had Dixonian legalism and Masonic realism or functionalism or principled dynamism ever come into contact? Hang on a minute, I found myself answering. There's no need to treat this entirely as a thought experiment. Dixonian legal method did, in fact, come into contact with Masonic legal method during the period of a decade or so when Chief Justice Dixon presided over the High Court and when a young Mr. Mason appeared before it as an increasingly popular junior counsel. Remember the case of the Queen against Davison, I found myself again saying to myself in this long conversation. There, the 29-year-old Mason, barely 3 years at the bar, appeared unled for the putatively bankrupt Davison before the full court of the High Court presided over by Chief Justice Dixon. On the other side was Mr. McFarlane QC, leading Mr. Reynolds for the Attorney General of the Commonwealth. You will see how the encounter went in the transcript, I thought. And so I called for the transcript. And I got it from the Australian Archives. And this is how it went. Dixon CJ. Who begins? Mr. Mason. I would submit that as the applicant, I begin. Perhaps I might say at this stage that it would appear to me that the matter is wrongly entitled. Dixon CJ. What should it be entitled? Mr. Mason. I would suggest that it should be entitled Davison against the Queen, seeing in fact that it is the hearing of the case, although in the bankruptcy court it was correctly styled the Queen against Davison. Dixon CJ. Well, without going into what the title should be, are you quite content, Mr. McFarlane? Yes, Your Honour, I am quite content. And so Mr. Mason began. When he had finished, he had failed to persuade the Chief Justice or any other member of the court that the Queen against Davison should have been entitled Davison against the Queen. He had succeeded in persuading the Chief Justice and 4 other members of the court that the sequestration order against his client was invalid because it had been made by a non-judicial officer in the purported exercise of judicial power. The sophisticated judgment of the Chief Justice is shown in the Commonwealth law reports to be one of which he is a joint author. It is apparent from the style and the content that he was the principal, if not the sole author. And it can be seen from a comparison of the contents and structure of the judgment with the contents and structure of the argument of Mr. Mason as revealed in the transcript, that one followed very closely the other. there was in the Queen against Davison, or Davison against the Queen, depending on how you see it, a meeting of minds. There was an amalgam of methods, and the result was a novel and principled exposition of constitutional doctrine, which has very much stood the test of time. The Queen against Davison, as we now know it, remains a leading authority on the nature of judicial power. The difference between these two legal methods is real, but in the broad sweep of history and looking back on that exchange as a particular example, the difference appears much less stark than it may have appeared at earlier times. Harking back to Tashnet, much of the apparent difference in methodology can be explained in terms of exceptionally good lawyers making exceptionally sound decisions in different institutional settings, in different social and political circumstances. That brings me to the second of the other two books. It was published by Federation Press, the publisher of this book, in 1996, as a collection of essays based on presentations made at a conference soon after Sir Anthony's retirement, having spent 8 years in the office of Chief Justice of the High Court. The conference was called the Mason Court and Beyond. I mention the book for two reasons. One is to highlight the significance of the title, which departed slightly from the title of the conference. And the other is to note something said in the contribution by Sir Gerard Brennan, who had been very much part of the Mason Court and who had become the immediate successor to Sir Anthony in the office of Chief Justice. So the book is entitled Courts of Final Jurisdiction. The title was particularly well chosen to capture the essence of what had occurred during the period of what was referred to in the book as the Mason Court. As Sir Anthony stressed on being sworn in as Chief Justice, elimination of appeals to the Privy Council just the year before meant that for the first time in its history, the High Court, under his Chief Justiceship, had the exclusive final responsibility for declaring what is the law in Australia. The buck had finally stopped here. No clearer example of the effect of that change in circumstances on permissible and appropriate judicial technique can be seen than in the context of Section 92 of the Constitution, by contrasting the earlier judgment of Sir Owen Dixon in a case called Hughes and Vale Proprietary Limited and New South Wales No. 1, with the unanimous judgment of the High Court led by Sir Anthony Mason during his first year as Chief Justice in the well-known case of Cole and Whitfield. The Dixon single judgment in Hughes and Vale No. 1 was a masterfully crafted piece of individual reasoning that was able to be read simultaneously as being faithful to precedent, whilst at the same time highlighting the flaws in the precedent, written in the expectation that it would be taken up and overruled on appeal to the Privy Council, as in fact it came to be. The Mason joint judgment in Cole and Whitfield, in contrast, but the contrast is very much attributable to the circumstances in which the decision-making was able to occur. It was a robust wholesale reappraisal of the entirety of the prior case law, confidently and authoritatively cast in terms of we decide. The contribution of Sir Gerard Brennan to the earlier book that I've mentioned was entitled A Tribute to Sir Anthony Mason. Sir Gerard describes Sir Anthony as combining a deep knowledge of the past with a vision of the future, which made him uniquely qualified to have led the Australian judiciary during a period which was inevitably to be one of change. Borrowing from Harlan Fiskstone's tribute to Benjamin Cardozo, the new Chief Justice said of his predecessor that he saw in the judicial function the opportunity to practice that creative art by which law is moulded to fulfil the needs of a changing social order. Underappreciated in Australia has been the impact which Sir Anthony went on to have after his retirement from the High Court as an inaugural non-permanent judge of the Hong Kong Court of Final Appeal, as a friend and confidant of successive Chief Justices, Andrew Lee and Geoffrey Ma, and as a sage guide and steady hand brought in to deal with the highest profile and most delicate cases. Bill Gummow's unique contribution to this book goes a long way towards explaining the enormity of Sir Anthony's influence in that role. Nowhere was that influence better summarised than in the official citation for Hong Kong's highest honour, the Grand Bohemia Medal, or GBM, which Sir Anthony received in 2013 and of which he is justifiably proud. The citation described him as a pillar of the court who had made immense contributions in establishing the reputation of the court in the common law world. After 18 years as a non-permanent judge of the Court of Final Appeal, nearly as long as his period as a Justice and Chief Justice of the High Court, Sir Anthony made the choice to end that second judicial career. He announced his retirement shortly before his 90th birthday, just shy of the age at which Oliver Wendell Holmes retired from the Supreme Court of the United States. Sir Anthony retired from judicial life, having shepherded into existence not one court of final jurisdiction, but two. I come then to the book at hand. There is very much to be praised in the individual contributions, all of which I have read. They are, however, too numerous to be referred to individually. There are 23 separate topics covered by 29 authors, with his usual enthusiasm and his characteristic industry. John Carter doubled up as a co-author on two distinct contract topics, so the number could perhaps be said to be 30, counting him as two, which he is. Daniel Farina is acknowledged as a research assistant in a footnote in an early chapter, and then appears again as a co-author in a later chapter, showing him to be a very enterprising junior counsel. My mentioning of John, the late career academic with specialised interests who has never been noted for being reticent about criticising judgments with which he disagrees, and there are many, together with Daniel, the early career barrister, obviously eager to do a range of work, is not gratuitous, it's not accidental, and it's not personal. It is meant to highlight an admirable choice made by the editors to limit the number of members and former members of the judiciary who've been invited to make contributions to the book, any number of whom would have relished the opportunity to pay respect to Sir Anthony. The editors have chosen instead to engage authors who span the academy and the profession and who span multiple generations. And the book is very much richer for that. And so too is the book's project of celebrating and perpetuating the legacy of one of our two greatest jurists. Expressing my own sincere appreciation to all of those involved, and particularly the editors. I don't know, I should have a gavel or something, but I at this point, with my pen, I declare Dynamic and Principled, The Influence of Sir Anthony Mason, officially launched. Thank you.
Your Excellency, Sir Anthony, and other distinguished guests. On behalf of my co-editors, Ben and Jeff, and all of those present, I'd like to first thank Justice Gageler for launching the book with his insightful commentary on Sir Anthony's standing and judicial career in a momentous period of final independence in Australia's legal system and later in Hong Kong. We're most grateful too to Justice Gageler and to Professor Gummow for their keen and continuing interest in this project right from its initial planning through to its completion, and for liaising with Sir Anthony on our behalf to ensure that we had included key aspects of his jurisprudence and to assist us fill any gaps. Their suggestions and of course their chapters add immeasurably to the value of this collection. The idea of the book to examine, analyse and honour Sir Anthony's influence on the law had been circling for some time, particularly after the publication by Federation Press of a book on the legacy of that other towering Australian judge, Sir Owen Dixon, in 2019. The immediate impetus for the book came, though, when the Francis Forbes Society of Australian Legal History called for applications for grants. Although money can't help one think and can't help one write, it can get a book off the ground by financing the assistance of one of our stellar student or graduate researchers, Daniel Farinya, who gathered essential background material, and then later Yannick Drevikovsky and Rahul Arora, who assisted with the painstaking detail of editing the contributions of 29 authors. 2 grants from the Francis Forbes Society supported this work, with top-up funding from the Parsons Centre at the Law School. We thank them all for their invaluable support for this collection. I'd also like to thank my co-editors, Ben and Jeff, for their tireless and thoughtful work in the editing process. And finally, Federation Press, the preeminent legal publisher in Australia, for their enthusiastic support and their tolerance for an ever-growing volume and their meticulous attention to detail. We saw this book as complementary to the Mason Papers, edited by Geoffrey Lindell and published by Federation Press in 2007, containing many of Sir Anthony's extrajudicial writings to that time. It's a great read, a volume of acute observation, analysis and commentary on aspects of the law, together with the gems of wit and humour that are so characteristic of Sir Anthony. It includes an interview with Liz Jackson on ABC Four Corners at the end of his term as Chief Justice, when Sir Anthony said he would leave it to others to define his legacy. This is what we ask contributors to do. As Justice Gageler points out, the volume could easily have been filled with chapters written by judges and lawyers, all of whom would have leapt at the chance to contribute. We decided to start with those who had served as Sir Anthony's associates, who, as is evident, have all gone on to fulfil leading roles in the professional judiciary. They all immediately said yes, filling up the spots. But university and academics all claim Sir Anthony as one of their own too. Not just the University of Sydney, where he studied arts and law and later taught equity, including to some people in this room today, until his appointment to the Court of Appeal, but also the Australian National University, where he was Pro-Chancellor and Fellow, the University of New South Wales, where he was Chancellor, with its Centre of Public Law named in his honour, and Cambridge University, where he was the Arthur Goodhart Professor of Legal Science from 1996 to 1997. And there are other institutions as well. Sir Anthony has always been a prominent and tolerant supporter of academic writing, whether by students in iconoclastic publications or junior and senior academics in learned journals. His own numerous contributions to law journals and conferences remain essential reading on so many aspects of the law. Again, every academic we approached from these 3 Australian universities enthusiastically agreed. In our teaching, we constantly refer to the exceptional clarity and logic of Sir Anthony's legal reasoning. As this collection demonstrates, there is at least one Mason judgment, usually many more, that stands out in every subject of the law curriculum. And like Sir Owen Dixon, that may often be a dissenting judgment. In Penfold's Wines and Eliot, it was Justice Dixon's judgment on conversion that is the most quoted of all the 5 judges. In Hospital Products and United States Surgical Corporation, it's Justice Mason's. Finally, on behalf of the editors, thank you to the 29 contributors, most of whom are here today, and there are sincere apologies from those who could not be. We know you enjoyed this project as much as we did. It's been an honour for us all to take part, and we all thank Sir Anthony for your support for the project and for your dynamic and principled influence on Australian law.
Well, as the Dean of Sydney Law School, it is my privilege to close off the event and offer this final vote of thanks. First, to thank the subject, the object of the study, Sir Anthony himself, for being dynamic and principled, not only on his influence of the law, but on so many people in this room and beyond. I think we all have our own personal stories of his generosity, of the way in which he took time, particularly with those less knowledgeable about the law, to answer their questions. And I think that was clear to me as a young academic at ANU in the 1990s, and also in Hong Kong when I was there shortly after he took the role on the Court of Final Appeal there. I'd like to thank Justice Gageler for an excellent launching, even though he didn't have a gavel. A Gageler gavel. We will be able to toast the launch of the book shortly. I'd like to thank my wonderful academic colleagues, to Barbara, Ben and Jeff, and all the contributors, obviously. It's a wonderful example of the extent to which the law school continues to bridge the academy and the profession, to produce a book that I think is going to be an enduring and fitting legacy for a truly inspiring legal mind. And of course, that's a term that I use a lot in relation to the Sydney Law School alumni. But I think here we have in our presence one of those truly inspiring legal minds. I'm very proud to count Sir Anthony as one of our alum, but also as a friend of our law school. Early in my deanship, he wrote to congratulate me, but in my response to him, I invited him to join us, and he jumped at that chance, and we had a wonderful afternoon with the students and senior colleagues and junior colleagues over lunch, discussing a whole range of really amazing cases and issues. He's been a friend of the law school and a friend of this particular dean for a long time, so I thank you for that. I'd like to acknowledge the Forbes Society. Legal heritage is so important. We're not terribly good at it, as we know from the way in which we maintain our records historically, but this is an important way of preserving, through the work of the Society, such important stories about the contribution of judges, named after one, of course, the most significant judges in Australia, Francis Forbes. I'd like to thank Federation Press. Now, Barbara mentioned that, and I turn here to my right. Without Federation Press, frankly, it would be so hard to produce so much of this, what they would say in those multinational corporations, local content, which of course is Australian law. And I think it's so incredibly important that we continue to invest and support the amazing work that Federation Press does with the Academy to produce work of this outstanding quality. So I'd like to thank Justice Leeming and Anne Toomey, Professor at Sydney Law School, as well as Jason Monaghan and the team outside, who have a stall there with the book ready for sale.
no doubt with a discount, I imagine. But look, I would commend it to you. It's an important contribution to the group of publications that they produce of enduring significance. I'd also like to thank them for sharing, laying on a wonderful reception outside. And it just falls on me now to say thank you, everyone, for your attendance, and please enjoy the hospitality outside. Thank you very much.